meeting is being recorded.
So welcome, Deborah. I'm going to thank you all again for being here. Let me just briefly introduce Deborah, although I think many of you know her. Deborah Kramer Radin is the managing partner at Kramer Radin LLP. Her practice concentrates on estate planning, trusts, wills, postmortem trust administration, charitable giving, tax planning, and end-of-life planning. Deborah is certified as an estate planning, probate, and trust law specialist by the State Bar of California of Legal Specialization. And she was named a Northern California super lawyer in 2019 and 2020. And we are just so lucky to have her as a special friend of Avenidas. So thank you again, Deborah, and you can take it from here.
Could you please mute everybody?
We muted. Be muted.
Thanks, Tracy. While you're doing that, I'll just get started. I'll dig in. All right. All right, everybody. So thank you all for being here. I want to start with thank you. This is, as you all know, this is the world we're in right now. It's not an ideal way to talk about this topic, I suppose, although the opportunity is that we all get to be in the same space, and yet I hope you all have ice water.
Deborah, can you unmute? I accidentally muted you. There you go. Thank you.
Okay, did I cut? Do I start again?
Yeah. This is this is not the ideal way to do this presentation.
Oh, okay. But I hope the opportunity is that, so I have tea. I hope the opportunity is that you are all somewhere comfortable, that you have your own ice water or tea or coffee or a snack. And, you know, the opportunity is that you're comfortable talking about somewhat a difficult topic. As Tracy said, and Tracy, thank you very much for the introduction. I've been involved in one way or another with Avenidas for, I don't know, maybe 10 years or so now, in different on the board, advisory, encouraging clients to participate in the many, many activities. So this is, this organization is near and dear to my heart, always. So I'm thanking all of you for being here. I also want to thank, I have some staff members who are on the Zoom with us as well. So if you see some slightly younger faces that would typically be in an Avenidas program, that's probably them, and you are welcome to say hello to them if you would like. So thank you to my staff members who are taking their lunch to be here. I appreciate it. I was asked to speak on some fairly basic, kind of the overview of estate planning, but I always clarify, using the word basic doesn't mean at all subpar. It means that these are the issues that I feel, and I think other estate planning attorneys in our area feel, are key for everybody to consider. And once you've got those basics, then you augment as you need. But this is the baseline. What I'm talking about today I'm hoping something in here will apply to each one of you. It's not going to apply, you know, everything I talk about won't apply to everybody. But what I'd like you to do is, as you're listening, think, okay, these are things that I should be talking to my own attorney about if you have a current estate plan. Or I should be talking to my doctor, or I should be talking to my daughter or my neighbor, or my financial advisor about. Or if you're in the role of caregiver and these documents sound familiar to you, are these things that you should be talking to the principal, you know, those who've asked you to step into these roles? So take notes with that in mind. And like I said before everybody got on, you know, there's some people here who I know could be teaching this class themselves, but so participate if you would like. Feel free to include questions or notes in the chat, because I think this is what's amazing about Avenidas is the sharing of information. A lot of it's legal, but a lot of it's also just life and experiences. So I expect you all to participate if you wish to do so. All right, let me see if I can get to the next slide. All right, I did it once. Sorry, everybody. There we go. Okay. So I'm going to be talking about, like I said, basic estate planning, but I'm going to be also including any changes that I've noted over the last year that I've been talking to our own clients about that I think are important for everybody just to be aware of. So good basic estate planning. Really, our job as advisors is to do a lot of listening and then give advice based on what we've heard. I can tell you most people, when they are coming to me and talking about their estate planning objectives, most of them will say, I want to make sure what I own gets passed as easily as possible on to my heirs, onto my children, onto my favorite organizations, whatever that might be for you. That's the primary initial objective. But then as we dig down a bit more, there's certainly tax planning that should be a component of every estate plan. Tax planning in our world will include a few different issues. One is the federal estate tax exemption, right? So it's not California, this is just federal. I might as well talk about this now. The federal estate tax exemption this year is about $12 million per person. Big number. Probably most of us are not at that level. As a married couple with a bit of good planning, that means you can protect 24 million, passing it on to the next generation or to your heirs without worrying about federal estate tax. The problem with that law is that it might change. So the current law, as it is drafted today, we've got that 12 million exemption. At the end of 2025, that exemption is scheduled to drop to about 5.5 million per person. It might change before we get to 2025. It may continue after 2025. We don't know. But when you're thinking about your estate planning and tax planning, know that that exemption may not be where it is today. The other tax that we're always aware of is capital gains tax or income tax. That has to do with, if I have Apple stock today and I bought it for $10 a share many, many years ago at this point, and I wanted to sell it today, I would have to pay tax on whatever the gain in value was over the years, right? So can we avoid that capital gain tax someday in the future? And yes, we can. We'll talk about that. And then property taxes. So I'll be talking about the changes in property taxes in California a bit later. We want to provide, usually people will say for each other, if there's a married couple meeting with me, and the balance is how do we provide for each other most efficiently and protecting each other, making sure our loved ones are cared for the rest of their lives. But then when we're both gone, where is everything going to go? And then financial power of attorney, advanced healthcare directive. These may seem like little throw-in documents, but they're equally important and this is where I feel estate planning is really, really, really important. Is clients who come to me don't always think about this, but how are they going to be protected should they need help at some point in the future? It's a hard thing to think about, and maybe it will hopefully never happen, but I want to make sure estate planning is, you've got the people you trust in positions to step in when they need to, and that when they need to step in, that they've got the legal power behind them to do what they need to do. So, all right, so that's the basic objectives usually. As part of basic objectives, this is really my non-legal bit of advice. I feel that if we're trying to pass things on as smoothly as possible, one thing that comes up all the time for really, really good reasons is avoiding elder abuse, avoiding getting taken advantage of. And I do feel if you've got people you trust in your world and you've certainly created documents naming certain people, somebody out there needs to know about those documents. It's not going to do much good if they're in a drawer somewhere and something happens and nobody knows what to do. or it might be an expensive process before everybody figures out what to do. So certainly I feel, as the attorney in this room, my ideal group of team members for you is my client. Perhaps if you've got a doctor or a medical team, that's an important component. Who handles your tax matters is important. Your financial advisor probably should know what's going on. It could be somebody at Avenidas. It could be a geriatric care manager, might be your family, your trusted neighbor, whoever that's going to be. But we all should know each other, and as much as you're comfortable sharing that information. I think it's one of the best ways I find for avoiding getting taken advantage of, because all of this team, everybody on the team the goal is to look out for you if you've asked us to do that. And we're all looking at this from different perspectives at different moments. All right, and okay. So again, basic just means usually comprehensive. Most people in California, not everybody, but most people that would come to me do need a trust. The trust that I'm talking about today, it's revocable, meaning that this is something you create during your lifetime. I'll describe it a little bit more. And again, those who know this by heart, you can maybe go get, refill on your tea during this time, but I want everybody to understand this. So usually a trust is important. A pour over will always accompanies a trust. This is something else to be aware of. I just had somebody yesterday who had been amending her trust on her own, and she didn't realize every time you amend a trust, you need to update your pour over will. Your will always wants to reflect the most recent amendment to your trust. So that's something to look at in your own plans. A strong, good, clear financial power of attorney. I'll talk about that in a bit. But that document I tend to update more often than other documents. I think banks, brokerage firms like to have that fairly current. The Advanced Healthcare Directive, of course, and I'll talk about that in a bit. The HIPAA waiver. So we've got these wonderful documents in place, but if nobody's allowed to get information that they might need due to our medical privacy laws, that could cause problems someday in the future. The POST form, probably a lot of you are aware of this, the physician order for life-sustaining treatment. This is something that I talk about as an attorney, but I can't actually sign off with my clients. This is something you and your medical team, your doctor, would talk about together. And it's really, really important to make sure that what you own is actually titled correctly. So somebody might come to me and have an amazing trust, an amazing estate plan. It all looks good on paper, but nothing is actually titled in the trust. Or they'll have IRAs or life insurance, and they've, over the years, just forgot that they need to name beneficiaries on those assets. So as you're listening, take notes. If you are spending an hour with me now, it's worth spending the extra time confirming with your financial advisor or online, however you do this, that indeed those assets that should have beneficiaries in fact do. And I'll note here, once you've double checked that, have a printout of that beneficiary form. Make sure that that information could be found at some point in the future. Again, when I, in my giving tidbits of wisdom, when I'm assisting families after a death has occurred, let's say an IRA, let's say you decided, my kids they have enough from my estate, they're getting plenty through my trust or my will or other assets. I want my IRA to go to Avenidas, let's say. If nobody knows that that's what you've directed, your IRA holder is not going to be able to talk to me or to your children. They're going to wait to hear from Avenidas. And if Avenidas doesn't know to talk to them, we've got a gap there that often causes expensive problems. So have this information available when it's needed. Okay, so how do we transfer, what we own? So going back, this is often the biggest issue that people come to me to talk about. How do I get what I own to my heirs, my chosen heirs? Gifting is easy. That's wonderful. If I could do so, and I wanted to write a check for $10,000 to every niece and nephew and my children and everybody, my friends, I could write those checks today. That's an easy transfer. Transfer by will is a transfer method. Again, I'm going to talk about that in a bit, why that might not be the best way to transfer. Intestate. So that's another transfer method. Intestate is the set of rules that California has come up with. So our probate rules tell us if I didn't plan in another way, California says where everything I own ends up. It might go where I'd intended it to go, or it might not. It might go to my spouse when I wanted to include my children, or my children when I wanted to include my longtime partner, or whatever. So intestate is not always the best option, but that's what it is. Contract, an example of a simple contract would be an insurance policy. You sign a contract with the insurance company to pay your premiums every year. The insurance company promises that at your death, whatever's left in that insurance policy, let's say it's $1 million payout, it goes to whomever I've directed it on my beneficiary form. So that's a good way to transfer assets potentially as well. Joint tenancy may be appropriate from time to time. Joint tenancy is fairly easy. So if I have a property and I want to co-own it with my sister, perhaps we will co-own that property as joint tenants. If I died yesterday, my sister submits my death certificate to the county with a form, and that property is now hers. We, as a married couple, we lose some tax benefits that we will otherwise get with community property. So joint tenancy is not necessarily the best way to co-own property with a spouse. We can talk, or if I had that property co-owned with my sister and I really wanted the property to go to my children, if it went to my sister, she might provide for my children later, or she might say, that was nice of Deborah to tell me what to do, but she's not around anymore. I don't have to listen to my big sister anymore. I want that property to go to my best friend, and I've lost control. So joint tenancy might be appropriate, but it's worth thinking through what the repercussions are. And then a trust. And that's where I'm going to focus on now. So I'm going to prep talking about trusts by describing what a will is. So a will alone, that's what we visualize when we say, and I hear this all the time, Deborah, I need help creating a will for myself. What the clients might be really talking about is I need a trust. But in any case, a will alone, imagine it's a letter to the probate judge. The good part about a will is it gives direction. So a basic will at minimum should say, this is my will. I am providing for whoever, my 2 sons in this will. I want everything to go to them at my death. And I've appointed my sister as my executor. So at my death, my sister as the executor would present my will to the probate judge. My will has no use or force whatsoever or power until the probate judge agrees. Yes, indeed, Deborah drafted a valid will. It goes through the entire probate process. Before COVID, probate process had some hiccups, but at least it went sort of smoothly. It might be about a year process. These days, with COVID and staff shortages and everything else that our probate staff is working under, it's could be a good 2+ years to have that will go through the probate process. Again, just talking about things that have happened in the last year or so, there have been a number of clients who've come to us who've said, my father drafted a will. We've had actually 3 probate matters in the last year. father was in the process of selling a property. It was in escrow. Very, very unfortunately, there was a sudden death. Father passed away, and that escrow halts. Everything screeches to a halt, and we have to get into the probate court to get the judge to bless. Indeed, this sale can go through. It's caused a lot of stress and a lot of expense unnecessarily. So for most people, a will alone is insufficient. Right, because of the fees, the costs, the time, all of that. Just to throw it out there, these numbers really haven't changed. So if I have $1 million probate matter and I'm the attorney responsible, my baseline fee is $23,000. That's what the law firm gets paid. My executor could take the same fee. So now we're up to $46,000 on a, in this world, you know, pretty basic estate plan, or estate with $1 million. The court gets its fees, the probate referee, there a lot more fees go out. So not the best choice usually. All right, so now we're talking about a trust. So I always describe a trust as a very long set of instructions, just like that will gave instructions, but the trust does a lot more than work simply at my death. So let's say this is my trust. They are my instructions, and over the 40 pages of this trust, I'm giving instructions today, and then I'm giving instructions at different triggering events over my lifetime. Or if this trust is my husband's and mine, these are our instructions today, and then over both of our lifetimes, this trust is giving instructions into those future moments. So in a trust, visualize, and this is, again, I'm giving the basics because as you're reviewing your own estate plans or thinking ahead to your estate plans, you start with wearing 3 hats, as I describe it. So you, or I should say me, this is my trust. I am the settlor of the trust, meaning these are my instructions. These are my words. I'm the trustee, meaning today I'm the manager. I get to make decisions about how I spend my money. Do I get a mortgage? Do I refinance my property? Do I invest? Do I have my accounts at Schwab today and tomorrow I decide to move them to Morgan Stanley? That's my business because I'm the trustee and I'm the beneficiary. I get to spend the money. As a married couple, we're both the settlers, we're both the trustees, we're both the beneficiaries in this moment. The settler hat never switches. That's always going to be me or me and a spouse. The trustee hat someday will shift to whomever we've named as our successor trustees. And that hat will shift at those different triggering events. So, and then the beneficiary hat also will shift, certainly someday in the future when we're both deceased. That will go to, in my case, our 2 sons. The triggering events, I'm going to touch on briefly now. That trustee hat shifts in 2 major moments. One is that if I've been declared incapacitated, so I can't manage my affairs anymore, that will go to our elder son. He's going to be the trustee now. Or I resign. I say, you know, I've been doing this for a long time. My son has an amazing financials brain, and he's great at communicating, and I trust him. I want to just sit back. I want to stay the beneficiary. I want to get all the benefit of what I've earned, but I want him to manage things. So the trustee hat can shift in the future, either because I've directed it, I'm incapacitated, or certainly at my death, that will shift for sure. And then the beneficiary, I'm the beneficiary as long as I'm alive, even if I can't manage things, but that will shift in the future. Okay, so talked about this a little bit. Yeah, actually I did. The trust benefit of a trust is that it handles all of those different eventualities. I'm incapacitated, don't need court involvement because the trust gives the directions that are necessary. I've passed away. We want everything to go to our 2 sons, but perhaps I want $10,000 going to 3 of my favorite charities off the top before my sons, or heaven forbid, one of my sons has predeceased me. My trust will direct that his share will go to his own children or his lovely spouse or wherever I've directed. So the trust gives all of those future instructions and all of those what ifs. As you're thinking about your own trust, look and make sure that the people that you've named as your successor trustees, as your beneficiaries, are still the right people. And if not, contact your lawyer and it's time to update. All right, so we've got this great document, we have a trust, things have to get in it. It's a bit of work, but once you get used to it, it's just, if you open an account in your name alone, it should not be more complicated. You open your account as trustee of your trust. That's it. That's as complicated as it should get. So I describe a trust. This teacup kind of looks like a coffee cup, but let's say it's a teacup. This is how I describe a trust. Imagine a trust as a teacup. We want the big items that you own actually titled in that teacup. So your home, your brokerage account, you could title everything in the teacup if that made sense. You could put your car in the teacup. You could say, at my death, my life insurance, I name the trust as the beneficiary. So that cash, that $1 million payout would end up in the teacup at my death. And then if things are in the teacup, easy, we just follow those instructions. So this is really, really important. Again, kind of non-legal, but you need to double check that the assets that you have are actually titled correctly. We want them in the teacup. Some things don't end up there, whether it's inadvertent or you didn't want to, or there's been a mistake. So let me go back. So we'll save that thought. I'm going to show you a picture again though. Okay, so see that teacup underneath is a saucer. And I'm going to be talking about that saucer in a couple slides from now. Okay, so going back to your trust, this is really, really important to review. And this is for married couple. So anybody, a single person at this point, you can listen. This might affect others in your family, or it might affect you maybe, but as a single person, you won't have a choice of an AB versus disclaimer trust. But this is important to understand the difference. So the AB trust, visualize, I'm going to jump ahead for just a moment. Visualize this brick wall. All right, now I'm going to go back. So AB trust says, in that triggering moment that I talked about, first death has occurred in this trust. Let's say for easy numbers, again, it's my husband and my estate. Let's say we were so lucky and we have a $6 million estate. Everything belongs to both of us. So it's $6 million together yesterday. But I get to use my husband as, I get to pick on him because he's not here in this room. So let's say he passed yesterday. I'm the surviving spouse. The AB trust tells me, Deborah, you've got $6 million. You have to put a brick wall up, right up through the middle of that 6 million. So for the rest of my life, I've got 3 million on my side. That's called the A trust or the survivor's trust. I've got 3 million on my husband's side called the B trust or bypass. Sometimes it's called an exemption trust or a marital trust. There are different names for it, but B is my husband's half. And he's giving me instructions. He's telling me, all right, it has to stay on this side, but I get to be the trustee. I'm still managing both halves, his half and mine. Depending on the trust language, the directions that he gave, I have use, benefit, and enjoyment from his half, but the limitations are his half has become irrevocable. I can no longer change the words of his half. We would do that kind of trust, choose that kind of trust primarily for two reasons. One is tax planning, federal estate tax planning that I mentioned at the beginning, and the other is for control. So he might be saying, I love my dear wife. I want to make sure she's cared for. She has use and enjoyment of my half, but I do not want her to give my half away to anybody else. She is much too generous and she's just gonna give it away to the animals and who knows who else. And it's not gonna end up with our sons. So he's locking in his words. My half, I can do anything I want with it. I can keep it exactly the same. It's going to our two sons, or I can make changes, my business. So AB is for control in part. And then the tax planning piece maybe is not so important to so many people anymore, right? That exemption is so high that if you remember the 12 million exemption today, so if I've kept 6 million in my own control, and that 6 million in its entirety passes to our sons when I've passed in the future, we've got a 12 million exemption. 6 million is very simply, smoothly passed. No taxes would be due. But again, we don't know where that 12 million exemption is going to end up. So with a $6 million estate, as a good lawyer, I'm going to tell you, or as your tax advisors would likely tell you, you don't know what the future holds. So don't just keep 6 million in your own control without thinking through. So if you didn't necessarily want the AB trust for the control piece, instead your priority is, we want simplicity, we don't need this split, whatever the reasons are, a disclaimer trust gives the surviving spouse some flexibility. So again, imagine that brick wall. Disclaimer trust says that brick, so same $6 million estate, the brick wall is under the sidewalk with a disclaimer trust. My husband is telling me, Deborah, I'm giving you my 3 million. If there are tax reasons to keep my 3 million on one side of the brick wall, well, then you've got 9 months to build that brick wall up so that my 3 million stays over here. Or maybe I decide I don't need the whole 3 million over here. I just want to put $1 million on this side and I get to keep 5 million on my side. So the disclaimer trust gives me, as surviving spouse, flexibility to build that brick wall up if it's necessary. And if not, it stays under the sidewalk and I move forward with my life with the entire 6 million. It's tough to explain by Zoom, and I'm sorry if this is too complicated on a Thursday afternoon, but follow up with your advisors or with me or whoever if this is something you're interested in. All right, so now the pour over well. So we've got everything in our teacup. Some things drip out. Imagine when you have a trust, your will is called a pour over will. It is the saucer underneath a teacup. It collects anything that may have dripped out, whether it was intentional or inadvertent. And the pour over will, very short, all it's saying, well, it says some other things, but primarily it's saying, get everything that's dripped out in that saucer back into my trust at my death. We want to avoid probate though. I told you that the will doesn't work unless it goes to probate court. Our probate rules, this has changed over the last couple of years, say whatever's left in that saucer, if in total it's under $166,250, we don't have to go to probate court to get those items back into the trust. I don't know where they came up with that number, but that's our number right now, 166,250. All right, briefly, so this was a really big change, and I'm finding that clients are coming to me and not really understanding this. So in February last year, Prop 19 went into effect. So for many decades, we all in California lived under Prop 13 and some subsequent propositions that said, when we transfer our property, or let's say our home, to our spouse or to our children, there's no reassessment of property taxes. Our children keep the same property tax base that we've been paying. Prop 19 did a couple things. The negative, or at least depends on how you look at it. I'm not going to bring politics into this, but so often people say the negative is that they eliminated the exemption for us to pass along our property from parent to children, or children to parent, if that's the way it goes. Property taxes will be reassessed when that transfer occurs. We still have the property tax exemption between married couples. There are some partial exemptions to full reassessment when we pass things on. So if we have a primary residence and we have a child who moves in or who lives in the home and claims that same home as a primary residence, the first $1 million of reassessment is protected before we start the reassessment. Proposition 19, though, also an opportunity. We can move anywhere in California. So we're not limited to certain counties anymore. So I could take my current property tax base. I can move anywhere in California. I could move to a smaller home. I could even move to a bigger home, and I can take my property tax base with me. And I think you can do it 3 times. So that's a change. This proposition also protects fire victims and there's some other exceptions. But this is a big one to be aware of if your plan was to leave your home to your children. Just be aware of it. It'll be more expensive, most likely, for them. Financial power of attorney. And I don't want to run out of time. So financial power of attorney, I visualize this document as I am giving instructions to my agent. So in that document, I'm appointing, let's say it's my husband first, my son second, my sister third. I am asking them at some point in the future when I need help, I want you to be me. I want you to be my hand and write checks for me or sign a contract for me because I can't do it. I want you to be my voice. If I'm in the hospital and somebody needs to call my insurance company to file a claim, be my voice and do that for me. Be my ears. If I can't hear very well on the phone anymore, I trust you and I'm asking you to step in and be my ears, my eyes, all of that. So financial power of attorney only works during our lifetime, because when I'm gone, I'm no more, these functions don't work. So power of attorney, sometimes children will come to me and say, I'm having so much trouble with the bank. My mother passed away and the bank, and I keep showing the bank my financial power of attorney that my mother gave me, and they're not listening to me. They're being so difficult and obstinate. It's because this document had stopped working when mom passed. But it's really, really important to have a good, strong financial power of attorney if anything should go wrong. So if I'm walking down the street, trip on the sidewalk, hit my head, I'm unconscious, this power of attorney could be really, really important so that my spouse or my children can step in and handle financial matters on my behalf. So do update this if you haven't in a while, or at least review it. And then the Advanced Healthcare Directive, really, really important document. I hope every single person on this meeting, has an Advanced Healthcare Directive, and that directive reflects your wishes. It's not going to do any good if you've got a healthcare directive that California put together for you or that a lawyer put together for you. It's got to be reflective of what you would want, and it needs to be shared with the people who are going to need to step in. I want to make sure you've got agents, right? The people who you're asking to speak for you or act for you, that they can be your advocate, that they, if maybe they don't agree with the decisions you've made and you've asked them to make for you, can they still be your advocate and still honor your wishes? I know in my family, I just got to say, I chose the law. We have a lot of people in our family who are doctors, nurses, medical practitioners. They know I'm the one in the room who faints the first sight of, a needle coming out. I'm out. I'm not first on my mom's healthcare directive, just to say, but I can do other things really well. So make sure you've got somebody good in your healthcare directive, that you've got an advocate, and that you've got a backup plan. No need to limit it to one person. The basic healthcare directive may be fine and sufficient, or you might have very specific end of life wishes, donation of body parts or not, or funeral arrangements, or did I say religious, spiritual wishes, whatever that might be, or what pain management looks like for you. So make sure that your directive actually reflects your wishes. Talk to your doctor about it. your attorney, whatever you need to do to get this in place. I always say to my clients, because it's true, anybody over age 18 should have an advanced healthcare directive at minimum. All right, and then the post form, again, that's not something I can sign with you. This is something that you and your doctor or medical team will be signing off on together. When I visualize the post form, it's that bright pink form, that magenta form. I visualize if it's in, let's say you've posted it on your refrigerator, or it's in a little vial inside the refrigerator, or it's right by your front door, and something goes wrong. You have a heart attack at 2 a.m. in your living room. The EMTs arrive at 2 a.m. I visualize the post form as my doctor is standing in the living room, giving everybody direction, telling them what to do or not do on my behalf. So it's a potentially really powerful document. So if you do sign a post form and you've got loved ones who may not know what you would want, make sure you review this with them so that they know what to do. All right. People often ask about gifting. That for many, many years, we were able to give, this is called an annual exclusion amount. We were able to give $15,000 to anybody we wanted every single year. The number's gone up to 16,000, a little bit of a inflation adjustment, I suppose. So that's often asked about. So many people, it's kind of a silly picture, but so many people say, oh, I have so much stuff in my house. Nobody wants my china. Nobody wants my antiques. I keep asking my family to pick and choose items and they don't want it. They've got, they've downsized, they're busy, whatever. It may be, that may be true. It may be that they're very polite, that they don't want to take something that they love seeing in your home, or maybe they are busy right now and they don't have room right now. I can't tell you how often personal items cause real stress, real sorrow, anxiety when somebody's died. I do urge my clients to write down where at least some of the items are going to go. For two reasons. One is for the organization of it and the ability to say, all right, I've got 3 daughters. One is getting the wedding ring set. One is getting the jade jewelry from Asia. One is getting all of the paintings because she's got plenty of wall space, or whatever it is. I want my grandchildren each to get an item. Or my nephew and I love to cook together. He gets my cookbook collection, whatever that might be. It's an organization. It avoids trauma. It avoids misunderstandings later. And it's also a really, really kind, thoughtful thing to do. When people are remembered, your friends, your loved ones, the other loved ones you're not including in your estate plan, they really identify those items with the person who's passed away. And it's a lovely way to hold a memory. So keep that in mind and make sure you do that if it's at all important to you, which I hope it is. All right. So the goal is good estate planning is that you can rest easy. You can, you've communicated your wishes to those you've entrusted with your care and with your future, the decisions that you've made. You've talked to your financial advisors, your friends, whoever it might be. And if you have named people that really aren't the best suited to manage things these days, that you update your estate plan. The other thing that's changed so much in the last couple years now is people have moved all over the world. Our kids have picked up and can work wherever they want. And maybe the person you thought was going to be right here in the community isn't now, and you need to think about a backup plan. So this is me, but I want to move on. We'll put our information in the chat. But Tracy, do you want to touch on, I think we have plenty of time for questions, but do you want to touch on what Avenidas is doing in this regard?
Sure.
Okay, so we have a few slides and I can click forward if you want.
Yeah, that'd be great. I I feel like I'm echoing. Okay. So I think most of you all know about Avenidas, but just an update on what we are currently doing. So we are currently offering our classes both in person only, online only, and we also have hybrid classes, seminars, and events. Of course, many of them are in English, but we also, through our Avenidas Chinese Community Center, offer classes bilingually in English and Mandarin. Our door-to-door program is currently providing Lyft rides only, monitoring Lyft rides. Our volunteers are on hiatus until we get through the Omicron surge, but they are also continuing with their grocery and medication delivery services for homebound folks, and we anticipate that that is a permanent addition to their services. We work with the Friendly Calls organization to do the friendly calls and outreach to socially isolated seniors. And of course, many folks during the pandemic have found the benefits of Avenidas Village, which is a virtual retirement community, so perfect for folks who want to age at home. We are Paula, many of you know Paula Wolfson, our social worker. She is the person who heads our Avenidas Care Partners. They do crisis intervention, the caregiver support, consults, emotional support. And as Deborah mentioned, she's someone who's definitely available for geriatric care consultations. Social work department also is available for information and assistance regarding housing and benefits and other resources that someone might need, any kind of case management, and that's both for low income and for paying clients. Rose Kleiner Center is in Mountain View. They are, I think they are reopening. They've been open, they were closed and they opened and they closed again. And I think they're reopening again next Tuesday for in-person services. Of course, that's a very frail group of folks that we serve through our Rose Kleiner Center. They do receive healthcare services and activities in both English and Spanish. Our LGBTQ programs, known as the Avenidas Rainbow Collective, is growing strong and will continue. We received some more grant money to continue those. So that's mostly an activity program, but we are planning on adding mental health services to that as well this summer. And of course, we always have volunteer opportunities, everything from driving when we get back to that. We need folks to make calls often. We have countless opportunities for volunteering. Next slide. And this is our information. You can email info@Avenidas or call our main number. We do still have the phones going to messages, but many of you have probably talked to Justin. He is the primary returner of calls and is really great at it. So please do leave a message. You can always email info@avenidas.org. You can email register@avenidas.org, and that will get our attention if you're trying to register for a class or activity. And of course, you're always welcome to email me personally. It's just my first initial T and my last name, McLeod, MCCLOUD@avenidas.org. Thank you.
All right.
So
I think I can stop sharing so that we can all see each other again.
Yeah, and I'll kind of go through. We had a few questions in the chat here. So folks are wondering if they can get a copy of the presentation emailed to them. So I will work with your office, Deborah, on that. The first question was from Chen. Chen asked, can we have the real estate go to kids after one of us die, even when we hold the title as joint tenant?
Not holding, so if you hold title as joint tenants, at your death, at the first death, that property belongs to the surviving spouse or the surviving owner, the surviving joint tenant. If instead you had wanted it to go directly to your children, if I understand the question, a joint tenancy deed is not appropriate.
So there's no way to change it?
Oh, you can change the deed, sure. And that would you'd want to talk to an attorney to make sure that you are actually changing the deed correctly as you both want. Sure.
Okay. Next question is from Bill. Bill said, I asked my doctor for a pulse. He said, I am still too young and have no medical conditions, so it isn't necessary. Would mentioning it in my advance directive be sufficient at this stage in my life?
All right. That's an interesting response. I'm not used to doctors saying, let's deal with that later. I'm assuming that was a good response from your doctor, but okay, so yes, your advanced healthcare directive can give all kinds of instructions to those who are next, but really what you're doing in a directive, advanced healthcare directive, you're doing two things. You're appointing somebody to act for you, and then you're giving them the directions that you want them to enforce. the advanced healthcare directive is not as powerful as your doctor giving those directions. So you've got to rely on the people you've named to actually enforce and follow your wishes. There's no age limit on a post form, just to say. So I don't know if your doctor was talking about you in particular, but and I'm not saying go to a different doctor, but you could get another opinion if you feel like that wasn't quite right. But you can do a lot with the healthcare directive, but not quite as powerful as the post.
Can I ask something on that? If
Mhm.
I go to a doctor that the day I turned 65, they said, we want a medical directive. So if you gave them a medical directive, they can't follow it without that pulse form?
Oh, no, they can. Your doctor can, well, your doctor is going to follow the agent's instructions. So whoever you've named, you've appointed to act for you. Yeah. Oh, sure. They can. But again, visualizing that 2 a.m. heart attack in my living room, the EMT is going to do what they're trained to do. If your child is appointed as your agent and the child is there telling them what to do, that's fine. But if the child is home asleep in his own room, 10 miles away, if you wanted to give direction when the child wasn't there, then the post form might be appropriate in that situation. And I'm kind of oversimplifying, but it's something to have your doctor explain how a post form would step in a way that's different than the healthcare directive alone.
Thank you.
Yeah.
We have a question from Richard, which is, how can we leave assets to our children that will keep those assets as their separate property, even through future possible divorces where their exes get the property, for example?
Sure. So many, there are not many, I suppose there are a variety of ways to make that happen. And I definitely would want you to review with an attorney the different options, because I'd never want to just, I'll give you one suggestion, but I don't want that to be the only suggestion that you walk away with. So, because it may not fit your situation, but you could say, in my case, I have 2 wonderful sons, but I want to protect them from, their spouses or their future divorces. So I could say my estate goes equally to my 2 sons, but they will each have a trust that I've created for their lifetime. So they'll have an irrevocable trust. Maybe they can be their own trustee and manage their own funds for the rest of their life. Or maybe I have somebody neutral because I really don't trust my son to protect his trust and his own interest. So a trust for each son in that case might be appropriate, but there are nuances to that. So that's one idea.
Veronica said, I have a post and an advanced healthcare directive. The advanced healthcare directive is in my refrigerator. Should my post be there as well?
That's what I've been told. So when I talk to EMTs, the fire department, they say that's what they're trained to look in the refrigerator or on the refrigerator door, one of those places.
Judith said under, and I assume this means under Prop 19, what about giving to your sister?
Under any prop, that there would be a reassessment of property taxes.
Okay. Let's see, who's this? This is Nandini said, if real estate and bank deposits are in a foreign country, how do you transfer it via a trust? Listed in a trust, sell real estate and transfer, how to sell after the owner is dead, name someone to sell now.
Yeah,
That sounds like a big question.
It is. It's an interesting question. So there is such a thing so I don't have all the answers without knowing more, but there is such a thing as an international will. You can't put foreign assets in a US trust, in a California trust today. The international will might be sufficient. I say that that's really just a Band-Aid. I've found when somebody has passed away and they have assets in foreign countries, and I work with attorneys in those countries, they say, Deborah, had you just told your client to get a basic will here or pay on death account, fill out forms in our country, it would have been so much easier. So I do, even though it seems duplicative, I do advise you seek legal advice in those countries. there might be an easier solution than we've got here in the US.
Can I add a little bit maybe to that? I'm not a lawyer, but since that question affects me, but just recently my brother passed away and we had a bank account in Europe, which 3 siblings on, and they don't accept a trust. So it was a joint tenancy. I will say in transferring the money and the assets from the bank, so far seems to be fairly easy because we're giving my brother's child her fair share, which is 1/3. My sister and I are not keeping the other 2, the other 1/3 ourselves. I mean, we could, but we're not, that's not how we handle things in our family. But anyway, that with the bank went fairly easy. We do have property. I haven't started to deal with that. So I don't know what will happen with actual property.
Excellent. Veronica, thank you for that. So that's a real life example. Sorry, go ahead, Tracy. I know there are different questions coming in.
So Yolanda wants to know, the person that did my living trust died. He said, do not ever write on your trust or on amendments. The person that I called that writes living trust said it's okay to write on amendments. What's true?
The problem with writing on a trust or an amendment on an original document, so the original document, is that you could be inadvertently giving other direction, or it's unclear. So if you crossed out, let's say my son had moved to wherever, Bali, because my 23-year-old son is talking about that, and I cross his name out and I put my sister as the backup trustee. Is it really, should it be my son? Should it be my sister? It could cause a fight. So your original attorney is correct.
Chen again said, if all my financial accounts have TOD set up, then there is no need to put these accounts in the trust, correct?
For that purpose, for passing assets on at death, that is correct. For managing things, if you're incapacitated, that's going to take further thought, whether your financial power of attorney is going to be strong enough to fill in that eventuality or potential eventuality. So there are other reasons to have a trust potentially. And pay on death or transfer on death, as long as those beneficiaries are living, sometimes people forget and somebody's passed away and they don't update it. So just think thoroughly through all of those what ifs. It might be fine, but it may not.
Okay, thank you.
Linda asked, are trusts, power of attorneys, advanced healthcare directives specific to the state, for example, California, or do you need to redo them, do them over or redo them if you also live elsewhere?
So I always say if you've moved certainly permanently or you're spending significant amount of time in other states, at minimum, you might want to consider a healthcare directive in those other states because they're very specific and you need them when there's an emergency. And it's nice that doctors, they can kind of visualize what they're, they already know what they're looking for. But if you're moving permanently, yes, every state has very specific estate planning laws and it should be reviewed at least.
Jay asked, if a valuable car is titled to my trust, should I sign the titles now as the truster pre-death to facilitate its sale or transfer? What issues will DMV have with titles in name of trust?
I may ask Jerry Spector if he's still on to weigh in. He puts his cars in the trust. I don't always do this, but
yes, I am on, and what I haven't done is I haven't transferred it, but I can tell you when I go to buy a new car, we always just put it in the name of the trust and it's not a problem. I'm not sure what the difficulty is if you don't have it in the trust. I don't think it's difficult. I think you just have to wind up dealing with DMV and be prepared that you're going to deal with someone at DMV that's no idea what you're talking about.
But AAA, it's worth a AAA membership. They handle
Yes.
transfers very kindly and smoothly. I don't think you'd want to sign over your car now. I think that would be premature. Maybe it would slip through after death and nobody would be the wiser, but I don't think you need to. I know when there's a death and a car is not in the trust, the trustee waits 40 days from a death. usually goes to AAA, and AAA helps transfer the car. It's that
You have
simple.
to show a proof of death certificate.
Thank
You
you.
have to have that. In
Yeah.
fact, I've heard you have to have lots of them because lots of
Thank you.
people will ask for them.
So
I'm
we
gonna
have-
add one, hey, Deb, I want to add one comment of a recent experience I had with a friend who someone took it out of the state and waited almost over a year before they wanted to transfer it. And you go to AAA and you go to DMV and they go, well, sure, but you know what? The registration's old now. So we'll be happy to do that as long as we get a smog certification. But meanwhile, the car is across the country. So
Yeah.
it's something you need to take care of at the time.
Life is messy. Yeah.
Life is messy.
Okay, our next question is, hi, who should have a trust?
Well, so in part, it depends what you own, but at minimum, if you own more than $250,000 of something, whether it's brokerage account, real estate, I don't know, whatever, oil wells, you should consider whether the trust is the right estate planning document for you. Or like Chen has mentioned, maybe having transfer on death on your accounts is sufficient. But if you own a property, probably a trust is still going to be the best choice.
Yolanda, again, a friend of mine has a mother with dementia, but she will not see a doctor and she doesn't believe there's anything wrong with her. We've all heard that one before. Who can declare her incompetent to handle her financial or medical problems? She won't see a doctor.
Yeah, it's such a hard, there's no perfect answer here. If it depends what the documents say. So if the documents say, before this person can be incapacitated, we need something in writing from a physician, whatever. So you have to look at the documents first. Richard, I will give general pricing. You have to look at the documents first. Sometimes things get worse before they get better. I think Paula Wolfson would have, hours and hours of thoughts on this.
Yeah.
Right. But it could be that there are doctors that certainly with the telemedicine now and Zoom, there could be an opportunity to have a doctor appointment with, and I don't know. So that's a hard question. Or the court, if it really, really, really got bad enough, a judge would get involved and would order an assessment. Also really messy and potentially expensive, but possibly an option.
Okay.
Jeannie, did you have a question about this? Or no, sorry, Tracy, go on.
Okay, Karen wants to know, can a spouse who gets our second home through our trust on my death give that home to my children from another marriage without tax consequences to my children?
Property tax, I talked about, so we've still got the property tax problem. Estate tax would depend on the size of your spouse's estate. More complex, and if you pass first, Karen, and you've got a certain value in your estate, I didn't really talk about this. There's a way for your surviving spouse to preserve your exemption amount. So if I've died, I've got a 12 million exemption. My husband can borrow my exemption and save it for when he passes away. So, Karen, for you, it depends on the size of the estate. It depends how your estate planning for each of you is set up. So federal estate tax could be managed probably. Property tax, it is what it is right now. And then income tax is not an issue. Unless you're talking about cost basis adjustment. It might take further conversation, which I'd be happy to have.
Deb, one quick, it probably would require, if you're then giving it to a child, would require a gift tax return. Then whether in fact there's tax as a whole, that ties into the estate tax.
Oh, if he actually gave it outright. Oh, I thought at his death, it would go to the kids. So sure, if he inherited that second home and then turned around the next 6 months later and actually gave it to them, yes, it would be a gift and husband would file a gift tax return. Thanks, Sharon.
And Deanie wants to know if it's possible to make a trust that will be valid in all states of the US.
Oh,
No.
not exactly. I mean, if you've got properties in other states, the California trust will work for all of those properties. But if you move around, it might. But for example, California is one of the very few states that operates under community property. So if you move, I think there are only 9 states maybe ish that have community property. So if you move somewhere else, what we do might not work there.
She would also like to know how to divide your estate equitably so there are no fights in the beneficiaries. Can you really leave $1 to whomever contests the will?
I know that goes to kind of, we could go down everything from parenting advice to everything in that answer. I wish I could control that. It would, we have an attorney in our office who handles litigation, and I wish she had nothing to do, but she is way too busy with this issue. I think every family is different, every situation is different, but I can tell you, disinheriting somebody, leaving them $1, leaving them $10,000 it's so hurtful, and you aren't there to mediate that fight anymore. It's left for others, and you can't change it. The words are what they are. So yes, you can do it, but certainly can't. Anybody has a right to fight, and if they're only getting $1, they have nothing to lose but to fight. So I would urge you not to. I know how emotions get involved in this, but anyway, but I want our litigators to be out of business, and they're just not. They're too busy.
So I think you told Richard that you would give some the costs for a trust for a single with 2 children who need their own 2 separate trusts, that you would take care of that.
Okay, so range, I'm sorry, I forgot this. So range of legal fees, I think it varies, of course, it varies attorney to attorney and how everybody sets things up. Generally, our estate plans, if it includes for a single person, including real estate, all of those documents I kind of breeze through, and some other documents, single person, I think, is generally between $3,000 to $4,000 for everything. For a married couple with 1 trust, and then all of those documents for each of them, is between $4,000 and $5,000. If it's more complex, if we've got multiple trusts, then we would adjust the fees accordingly. So that's a big range. So it's really specific to the person, to the family.
Okay. I didn't see any more questions in the chat, so I think we've
There's
got all of
one more.
our.
Some people have their hand raised, though.
Oh, there you go, Jeannie. Thank you. I was looking for who had their hand raised. Thank you,
Oh,
Jeannie.
thank
Go
you.
ahead.
I have conscientiously gone through and made sure all of the assets are titled correctly. I'm a surviving spouse. But recently my bank, and now I'm starting to think about making sure my daughter will have access to some assets or access to some cash without having to liquidate assets in a hurry when I die to cover who knows what. But my bank told me that my checking account, which is titled to the trust, that I can't put her on as this authorized signer unless I take the account out of the trust. Is that correct? And what should I do?
Bank is correct. And if that account does not have direct withdrawals or deposits, or even if it did, I suppose if you want somebody to have direct access to funds, whether you're suddenly incapacitated or you've passed away, sure, you can add them as a co-owner, but that means technically it's their money at your death, right? If that's that joint tenancy, and just keep it small, keep it just for $5,000 or for that purpose. Does that answer?
Use the checking account for all my expenses. And auto pay and so on. So
I would set up leave that one alone then, and set up another account. Don't change the title of that one. Just set up another one with a bit of money. Your advisors might have other answers, but that's what I would do.
And I have
What about the
financial power of attorney? Couldn't that be used to access the bank account?
During your lifetime, but not at your death, right? It stops working at your death.
This is very helpful. Thank you. I'm thinking I might consider keeping a CD with joint, title to joint at the same bank, because she could liquidate the CD.
But ask them if they're there may not be, but penalties for early liquidation, or might it take longer? So again, you're the more the financial people in this room or your advisors might have other ideas but yes.
That's super. Right now I have one that is no penalty, 7 months. So it doesn't tie up money too long. Thank you very much.
Couldn't she do a POD on that?
Sure, but you have to wait for the death certificates before the beneficiary has access to the funds.
So,
But yes.
So does that mean someone should have perhaps an account that there's a joint just to cover burial services, because they might not get access to your money right away? They're not going to sell my house the day I die. I hope not.
No, they won't. They won't. Even if they wanted to, they couldn't. Yes, that it is an option. If these are people you trust, if it's, these are your kids or your sister or whoever, and you say, look, they are not going to take advantage of this. They know what it's for. They know it's for expenses. It's not at my death, they're going off to Hawaii and leaving the mess for everybody else. Then yes, that would be an appropriate
Inappropriate to leave the body in the house.
Yes, I'm off to Hawaii because I just suddenly got $5,000. So I don't mean to make light of it, but just think through the repercussions and make sure the person who you're adding knows what's going on and why.
We did get another question. It's, should we consult a lawyer about a trust created in the 1990s? In other words, have laws changed that would require us to update it?
So a few things. Certainly the drafting choices might change. I can say that as every client goes through an event, it's harder to get access to financial accounts, or the elder abuse laws have changed. Things, or HIPAA came into effect. That changed everything. It's worth reviewing your estate plan. I mean, I say when clients walk out with an estate plan, I ask them to check in every 3 to 5 years. I don't generally hear from them every 3 to 5 years, but that's my goal, because it's just worth reviewing. And there may be no changes, but yes, there have been enough changes that you should review it.
I think we had a couple other folks who had raised their hands. If you want to speak up now, because I'm not really good at this and I don't know how to find you. So
Can I go? This is Jean.
Yes, Jean.
First of all, I thought this was scheduled at 2. I'm so disappointed I missed it. Can I get the recording?
Yeah, we're going to be, the recording will be posted, maybe not by tomorrow, but certainly by early next week. We'll have it posted on the Avenidas website, and we'll probably also include a link in that Friday electronic newsletter that you all hopefully are getting.
Okay, so I could go to the website. Is it avenidas.org?
Yes, that's correct.
Okay, and then my question from listening to others, I'm an authorized signer on my mom's checking account. Her checking account is in the trust, and I have durable power of attorney. And so I didn't know that I wouldn't be able to act at her death, but I am also the named successor trustee.
Yeah.
So I would be able to access it because of that, right?
Exactly. Yes. And
okay.
Whatever. So I just to super briefly, because I did briefly touch on this, but a trust will tell you at which points you can step in. Either your mom resigns and says, Jean, I want you to be my trustee now, today, or I want you to serve with me as a co-trustee. That might happen, or she's incapacitated, or she's passed away. So you just have to read her trust and see what are those triggering events.
So she can resign or be a co-trustee?
She could, if that's appropriate.
To resign, how would she resign?
Depends on the trust document. I'd have to, or whoever would have to read the trust document itself and follow the instructions in the document.
Okay, so I could read it and maybe get some guidance there.
Definitely. That's the starting point.
Yeah. We've got,
thank you.
We've got two questions about cost. So maybe you guys could send
Yeah.
those to inquiries@kramerradin.com.
Yeah,
Inquiries,
basic.
yeah.
Yeah, just
Yeah.
basically, if our office is updating an estate plan from another attorney, we would have to probably restate. It's probably going to be in that same price range.
Yeah.
Reviewing a trust, just reviewing documents, definitely inquiries. We would be billing either, I have wonderful associate attorneys that bill at a lower hourly rate than I do, but it'd probably be an hourly matter just to review and give you an assessment.
Yeah,
And then
it looks,
yeah,
yeah, it
Karen.
looks like Karen's is also kind of about costs too. A friend recently lost her spouse and they had an updated trust, but she's finding there's major expenses to get it all worked out.
There are, yeah, and it's usually tax-based. There are appraisals to get, there are legal fees, the documents, it's not always just automatic to transfer assets. It depends on how the estate plan is written, but it's usually tax-based.
Yep.
Yeah, just to be aware of that, yeah.
So I think we've got everybody. So again, everybody, if you have any further questions or would like to consult with Deborah or someone in her office, you can email inquiries@kramerradin.com. Just let her know you were in the Avenidas presentation. And I just want to say thank you so much, Deborah. We're so glad. We get requests for your session throughout the year. People remember it and they want their friends to hear about it. So we're so appreciative that you were able to give us a little bit of your time today to give us this very, very important information.
My pleasure. It's always a pleasure to be with Avenidas, and I haven't been in the building in so long. So thank you all for letting me join you.
Yes,
Pleasure.
thank you so
very
much.
Thank you.
Thank you so much.
Bye, everybody.
Bye.
Bye.